I'm Deb Dumontier, and hope everything's okay with Dave. He hasn't shown up yet, so we're just going to launch into it. My presentation starts at 8:30. We're going to keep us on track here, but it's my pleasure to be here today. I am a federal employee. I work with the Office of Special Trustee for American Indians. I'm the Deputy Special Trustee for Business Management. And even though I've been managing the IT program within our office for some time now, technology always baffles me. I love it when it works, and it always takes a little bit of time to get set up. And so we got a lot of it going on here, which is exciting. We are webcasting, and I understand we have about 20 participants that have remoted in, so thanks to them. And we also have MCAT, they're broadcasting as well, and then we're recording this event. So we'll get started. Again, I have worked in federal Indian law and in Indian country for over 20 years. I'm a graduate of the university here, and my undergrad, as well as law school, and my master's in public administration. So it's always exciting to come back and present. And it's great to see all of you. It's great to see the colleagues here, some new faces, and it's our opportunity to present on a very important topic. And one of the things that I generally do is I take your feedback from each presentation. And we've had a great opportunity of presenting this series for about 4 years in a row now. And there's some constant themes that come back with the feedback. And those folks who have joined us by webcast, you'll have an opportunity to provide feedback as well. So please do, because that helps us with the presentations. We try to improve this every year. But one of the themes that I'll generally see is people will disclose, well, given the time of year, I just needed the credits. And this was a good time for me to attend. And that's great. What's been interesting, though, is they generally will report that the presentations are interesting, they're practical, and they feel that they have left here that they can actually draft a will. So that's very exciting for us, a convert, right? Someone willing to do that, so that's great. The other theme that generally will come out is that the information is repeated but in different ways, and we have kind of set it up that way. I provide like a general overview, a brief history and the importance of drafting Indian wills. And I kind of think of it as a puzzle. I'm kind of like the edge pieces, framing it in. And then we have experts following me that are filling in the gaps. And these are folks with on-the-ground experience. And so we have our fiduciary trust officers with OST here, Carrie and Lynette. And we also have Francis Gary with the tribe. And it's nice to see we have some other tribal employees here as well. But they're going to share with you their experiences and their knowledge, their tips, and they're going to start filling in some of that puzzle. And then we have Chief Judge Waits from the Office of Hearings and Appeals. And he is going to give you a comprehensive overview of the American Indian Probate Reform Act. That's our main topic today. And he's also going to give you his perspective as the chief judge adjudicating these administrative proceedings. So it's a great opportunity to ask questions. And then we round it out with Joe Hargrove, and he basically will provide the nuts and bolts of drafting it, pen on paper. So when you leave, you're going to have the full puzzle, all the pieces, and the picture is going to look like a big sunshine that we haven't seen for a while yet, right? So we're going to have a lot of technology going on here. We have the PowerPoint on this laptop, so we can share it via webcast. I have notes on my really fancy laptop that I just received and don't really know how to use it. It knows more about me than I know about it. So please bear with us. Also, again, so one of the first things that I kind of throw at you, we refer to this series as Indian wills, Indian will drafting. In a sense, it's kind of a misnomer because it's a shorthand reference. And you'll see I have here drafting wills, writing wills for tribal members. It is kind of a misnomer. It's not an inaccurate term, but you're going to be drafting a last will and testament. It is a last will and testament. It is the legal document for that individual's estate. It just happens to be a person with an estate that has trust property, but they may have others as well. So I always remind people that this is a last will and testament, even though we do refer to it as Indian wills. And again, I'm going to give a very broad, comprehensive overview and federal Indian law and policy. And why do we do that? It kind of helps to put it in historical perspective. Like, what are we doing and why are we doing it this way? The fiduciary role. What is it? Whose role is it? What is the trust? What is the federal administrative process, and what is trust reform? I talk a lot about OST, the organization that I work for, because we've been part of trust reform for over 20 years now. And then we look at the legislation. Kind of in the 80s, kind of later, you know, we started seeing some federal legislation regarding Indian lands, the Indian Land Consolidation Act and amendments. We refer to that as ILCA. And then the American Indian Probate Reform Act, APRA, came along, our first federal probate code. And then we had a lawsuit, we had a settlement, the Cobell settlement. We'll talk a little bit about that because out of that arose the land buyback program. So understand when we talk about these overviews and when they're not comprehensive, that it can be kind of mind-boggling in a sense. It's kind of like you're standing on top of the hill with a little snowball behind you and you're running and the snowball gets bigger and bigger and then you have pinwheels beside you. I'm not going to do that to you. Every bullet I have here could be a presentation for the day in and of itself. And a lot of you are experts here. So if I gloss over something that you think would be helpful, hey, please jump in. We're here to learn from each other. We will today. So please share your experiences. Appreciate that. So part of the corner pieces of our puzzle, we always look for the corner piece, right, is this time periods of federal Indian policy when the United States was becoming the United States. First, they started with treaties with tribes, treaty for peace, for protection, for resources. Those are supreme laws of the land. They're still supreme laws of the land. So treaties is the time period that we start looking at. Evolving into removal of tribes to the reservation systems, where we see reservations, tribes moving to the west. And then in the later 1800s, the time period that we're going to be talking about are the impacts from the allotment period, the allotment and assimilation. And that's where we see this, the ownership from communal tribal to this concept of individual, and the direct and indirect impacts from that time period. And then we see a shift to reorganization, a re-recognition of tribal governments. Not that they hadn't been recognized, but a federal way of recognizing them. We don't talk a lot about the termination and relocation time period, but I think it's important to know about it. Termination was a time period where the federal government identified some tribes and felt, hey, these tribes are pretty self-sufficient. We can basically terminate the federal trust responsibility that we have with these tribes. And it started as a House Concurrent Resolution 108 in 1953. Flathead, Salish Kootenai tribe, was the first on that list. They were not terminated. There was a lot of advocacy by tribal leaders, by congressional leaders, so they weren't terminated, but a number of tribes were. And since that time, a number of tribes have been re-recognized because that relationship is extremely important, that trust relationship. And then relocation. Some of your clients you're going to run into are going to have a history that's different than some people who have been born and raised here. Relocation was a time period where individuals, sometimes our parents, our grandparents, for training or job purposes, were relocated to other states. And sometimes they stayed, sometimes they came back. So they may not know a whole lot about what they own or about their tribe, so that's something that you may run into as well. And then self-determination. The current time period that we're in now, recognition of tribal sovereignty. And what's interesting is today the Senate Committee on Indian Affairs is having an oversight hearing on self-determination. And it's self-governance, the 30-year anniversary. So it's looking where have we been and where are we going to be in the next 30 years. So that is going to be 12:30 our time. They generally record those so you can watch it later. I think it'll be really interesting to see what the tribal leadership are going to be reporting on where we've been and where we're going to be going. Yay. It didn't freak out. And neither did I yet. No. So the historical background, the General Allotment Act. It's the Allotment Act that authorized the president to allot portions of tribal lands without tribal consent to individuals. And generally it was 160 acres to head a household, sometimes 80 acres to others in the household, sometimes 40 if it was irrigated. Sometimes there was specific legislation. This is not something that tribes was taking lightly. Some of them were clearly fighting, and Flathead is another example. They weren't allotted until the Flathead Allotment Act of 1904. So some tribes you're going to see are going to have specific legislation. But not all the reservations were allotted, but a number of them were. 219 were allotted, and it was about a 50-year time period. The owner is actually the United States government, owns the title for the beneficial interest of the tribal member or of the Indian. And then after allotments, it wasn't uncommon. There were about 46 reservations that were open to homestead. And so now you start seeing a whole new land ownership introduced onto these reservations to non-Indian homesteading. So about 90 million acres were lost out of tribal holding. So it was a substantial reduction, about 138 million down to about 146. Allotments were to be held in trust by the federal government, so they shouldn't be lost, they were going to be held in trust. And interestingly, what comes into play for us, state intestacy laws generally applied. Heirs took land as tenants in common, so equal share, and when they passed away, their share was by tenancy law, would go to their heirs. And so we started having this term, what we call fractionation. And we're going to learn more about that, and we're going to hear a lot about that, but it soon became a really serious problem for the administration, the federal administration. Now, another interesting thing that happened during this time period.
I have the mic to right here on your jaws, actually. They're having trouble hearing me online.
Oh, I could say good.
Right there. And I'll adjust your volume.
I'm adding it to my jewelry. Okay. But another interesting thing that happened during this time period, so you think about these allotments given to individuals, and they'll have 25 years, there'll be no tax, it'll maintain this trust status. But there was a law passed in 1906 called the Burke Act, and that allowed the Secretary of Interior to issue fee patents like many of us hold our land. And within just a 2-year time period, 60% of the allotments that were granted at that time lost their trust status. They went into fee status. So you can see there was a myriad, a whole conglomeration of land ownership on these reservations. That's the history, that's the impact we're looking at now. Fortunately, that policy shifted, and it was based on the Merriam Report of 1928. It was a commissioned report. And it documented that the allotment policy was a failure. It wasn't working. And there was a shift in the mindset at that time that tribes not only were recognized as indefinitely being existing, but they should be recognized as indefinitely being existing, and they should be supported. And so the IRA was this major shift in federal Indian policy. It stopped allotments. It extended that time period of trust allotments indefinitely. It restored the surplus lands that had not been allotted on reservations or open to homestead, restored them back to the tribes. And it authorized the Secretary of Interior to hold land back into trust, take it back into trust, and established a form of government that the federal government was recognizing for tribes. And CSKT, Salish Kootenai College, the Salish Kootenai tribe, I talk about them a lot in self-governance because they're one of the first in many ways, and they were the first to have a constitution under the Reorganization Act. They also were one of the first to establish their own land buyback program. So they started purchasing land back. Now the direct impact was the loss of the land. Another direct impact was a checkerboarding. And again, at CSKT, and some of you have seen their maps, where we start with the treaty period where their map is all green. And sometimes you hear the CSKT leadership and the staff, they talk about turning the map green. Well, what happened when you look at the colors of the map, allotments was represented by orange, and you start seeing orange on their map. And then you start seeing federal lands, purple. You start seeing the homesteading, which is a tan color. State lands that were issued for school purposes, so you start seeing all these checkerboarding colors. We refer to that as checkerboarding because that's what it actually looks like. And the direct impact from that is also jurisdictional issues. And many tribes have dealt with this jurisdictional issues based on the multiple interests that they're dealing with. Inheritance has been pursuant to state law. And the difficulty there is, sure, if you just own in Montana, it's Montana state law. Judge Ways can talk about prior to APRA. But oftentimes folks will own trust property in Montana. They may inherit at Colville in Washington. They may inherit at Umatilla in Oregon. And so you see in that particular case, you're gonna have 3 different state laws that would apply. So it's gonna be very complicated. The more complicated a case is to probate, the longer it's going to take, right? Indirect was this fractionation, this multiple ownership. And I provided a website here. The Extension Office, MSU Extension Office, has these little fact sheets, they call them fact sheets. And they haven't been updated for a while, but they're still pretty informational. And when I present here, oftentimes to the law school classes, I'll be invited and we'll start talking about fractionalization. And for some reason, it's something that when you grow up with it, you just kind of get it, you understand you have multiple owners, but sometimes it's a hard concept to understand. And if you think about it, here's the chart, and I'll just pass this around. You can Google it as well, but you start with one person, and then you have intestate law apply, and they have 3 children. All of a sudden, you have a third of each. You have 3 owners, and those children all have 3 children, and then pretty soon there's 9 owners and on one interest, and it just keeps multiplying and multiplying, multiplying. And of course, the other issue with fractionalization is oftentimes, generally, you need owner's consent to use your own property, so you need the other owners. As you start moving down generations, you may not even know your co-owners, so that can be very difficult. So heirs would take as tenants in common, and they hold an undivided share. There wasn't even authorization for individuals to draft a will until the Indian Wills Law in 1910. So if you think about like a flathead that was allotted in 1904, or even very early on under the General Allotment Act, you started having fractionated interests accumulating by intestate laws. And even if you wanted to leave it to one child, you didn't have that opportunity until 1910. So again, you can see that there was this issue that was identified in 1928 by the Merriam Report. The IRA had a probate code in it, it just did not get passed, which is very interesting because as the time periods go on, the more fractionation that we have. Pre-APRA, prior to the American Indian Probate Reform Act, spouses, non-Indian spouses would inherit, and it created another unique form of ownership. I refer to it as a passive trust, but the federal government doesn't hold trusts for non-Indians. So you have one allotment that can have all types of ownership on it that can be extremely complicated. So we had some federal legislative efforts, but they started kind of late. They started in the 80s. Again, you know, thinking about the Indian Organization Act, it was the first legislation that started to address land issues, again, recognizing the Secretary could take land into trust, lots of unique things. But there was a lot of probate and non-probate things that were not being addressed that the Indian Land Consolidation Act in the 80s started to look at. And the first efforts did not work out too well. In 83 and 84, the law was amended. But the thought for the probate and the federal probate law was that if you had interest less than 2%, couldn't be worth a whole lot, that would just a cheat to the tribe. They tried to amend it to put a value on it, or if you had a will, but the United States Supreme Court, in 2 cases, Hodel and UB, looked at that and said, hey, that really is a Fifth Amendment taking. That's unconstitutional. So they had to go back to the drawing board for the probate piece. In 2000, the Indian Land Consolidation Act amendments were passed, and there was a probate provision, but the Secretary didn't certify that provision. The non-probate provisions are effective and continue to be effective now. But that was in 2000. And I happened to be on the work groups that worked on ILCA and the ILCA that eventually became APRA. And 4 years later, we have the American Indian Probate Reform Act. And we're going to talk about these bullets a bit more, and you're going to see them as a theme throughout. But the American Indian Probate Reform Act became effective June 20th, 2006. It's been amended, but it replaced state law. So now we have a federal probate code for any individual who should pass away on June 20th, 2006 or forward. It carried out the intent of ILCA to limit fractionation, to prevent the loss of land going out of trust, so to keep land in trust, to promote land consolidation so that it could be used and have value, and then owner management provisions. He's not here. I'm hoping webcam people can hear me better. Can you guys still hear me okay? Okay, thank you. So why is Indian estate planning important? Well, you know, as attorneys, we're trained, we protect, prevent, provide. We have the opportunity to educate and inform and assist our landowners to understand the process and the terms. So I look at it as, you know, I've always been very fortunate in my positions that I've had with the tribe or with the federal government to empower individuals, to give them the information they need to advocate for themselves. And the terms are important. I know probate terms are difficult, we don't use them a lot. I just took some training at the tribe for Windows 10. And one of the first things that they said, the instructor said, you know, you need to learn the terms. Because when you're working with your IT tech folks, they may not be on site. So I learned that little menu thing. I always call it a menu. It has a menu on it. That's a ribbon. You know, sometimes my ribbon goes missing, but now I know what to ask for. So the terms can be important. It also, if we have a will, it can facilitate the probate process. So it can help get ownership to those heirs a bit quicker. We also have the opportunity to discuss the impacts of APRA. Now, when you think about, from the government perspective, what is the problem? It's the fractionating. It's the multiple interests, right? So APRA has been developed to limit who's going to inherit without a will. And if you think about the interest that you may inherit, you know, we were talking about spouses would inherit, whether non-Indian or Indian. But when you look at APRA now, without a will, a spouse is going to inherit a life estate. Now that may be fine, that may be with what you want, but it's something you need to be aware of. So understanding what the impacts of APRA may be, and if you don't have eligible heirs, the tribe now, in the way I try to explain it, I guess, there might be a better way of explaining it, but they essentially sit as an heir. It's not a cheating. They're the next to take if you don't have certain eligible heirs without a will, okay? So of course, the more we learn, hopefully the more our landowners will want to use wills. One thing you're gonna hear us say more than once, right now, the federal law requires no matter what the value is of your trust land or trust funds you may have, there must be a federal administrative process to adjudicate that interest, okay? So wills are still important. We know in everyday estate planning, we try to plan so you don't have to go to a probate. Currently, right now, we don't have that tool. So, and again, reducing the complexity of the estates. If you have a will, you have that opportunity to do that. The other important piece and why it's important is after APRA was passed, Interior used to provide will drafting services through the BIA and the Realty Office. They had will scriveners, and they would provide that service. They stopped providing that service in 2005. It's been a while now, but they also stopped storing wills. It's been a while as well. The unique thing, and why it's great to have Francis and Kay Deckers here as well, the tribe, in compacting the realty program at CSKT, they have the opportunity to continue that service, and they do. They do provide a limited service to their membership. I think Interior, in looking at the document itself, being a legal document, and the concerns of potentially providing legal advice, they felt that would be better off done by attorneys. And I think Joe will also explain, you know, some of the work that he does. It's not that complex, but we are estate planning. And the bottom line is we need to build a capacity amongst our state bar to provide this service to a unique set of individuals. Otherwise, they're not going to get the service. I would provide outreach to our landowners and let them know about APRA. They wanted to get a will, but they would report back they just couldn't find attorneys to do that. So hopefully we're changing that. And I thank all of you for being here to help us do that. So Department of Interior and the role of Department of Interior. This fiduciary trust. Well, it's the land. There's still a land base, about 56 million acres in trust. And then you see there I have 57 million acres of subsurface. It's not that we make this easy. It is possible to have a tract of land where that interest has been severed for some reason. Maybe the allotee sold the service. Years past, they retained title of the subsurface with the allotee because they didn't necessarily know the value. And so that interest would continue to fractionate. We do have more subsurface held in trust than we do a surface. About 10 million of it belongs to individuals, to individual Indians, and then a great portion of it belonging to tribes. And Interior has the fiduciary responsibility to manage the trust, the land and the funds, the income. And there's hundreds of leases out there. BIA, the Bureau of Indian Affairs, they manage the resources. OST, we receipt the funds, so we have a segregated responsibility. We'll talk a little bit more about that as well. So who's the trustee? The Secretary of the Interior. Congress has delegated as the trustee for Indian trust funds. And it was the IRA, the Indian Reorganization Act, that actually recognized that the federal government was a trustee. So the delegated authority is with the Secretary, who happens to be Ryan Zinke from Montana, strong supporter of sovereignty, self-governance. I don't know if you can kind of see here on the screen, but this is blue. This is where the Office of Special Trustee is located. We're in the Office of the Secretary. Sorry. I'm trying not to do that. Maybe if I just hold it, then I'll have more things to do with my hand. Also, I'd like to point out on the far side over here, we have the Policy Management and Budget. And that's actually where the Office of Hearings and Appeals is located. That's where Judge Waite's office is located. For a number of years, OST has been managing appraisals. And here recently, appraisals is going to be consolidating with appraisals that are done by Interior in the Office of PMB. We'll talk a little bit more about that. And then if you see down here in the yellow, this is the Assistant Secretary of Indian Affairs. We're BIA and BIE. So when you think about this process, we're not even in the same direct line of chain of command. When you also see all these other assistant secretaries, Reclamation, Fish, Parks, they have a trust responsibility as well. So we don't want to diminish that responsibility. But it is BIA that's responsible for the resource management, and it's OST that's responsible for the funds management. Talk a little bit more about OST and how we're created, but just keep in mind there is a thought that OST could realign under the Assistant Secretary of Indian Affairs. Sometimes it's helpful to see the visual. So the American Indian Trust Fund Management Act of 1994 created OST. And it was in strong response to tribes that were demanding accountability and transparency of the trust funds. But the primary purpose of OST when the legislation was passed was for overseeing and coordinating trust reform. Well, a unique thing happened a couple years later. By secretarial order, OST started an operational responsibility of management for the trust funds. So what does that mean? It meant that the Office of Trust Funds Management, a program in BIA, those responsibilities were shifted over to OST. So we started operating. We've been operating those funds for about 20 years now. But when you look at the legislation, one of the first things that you'll see in Title I is this recognition of the trust responsibility to account for daily balances, to have an accounting. Trust funds also could be withdrawn by tribes and managed. That was another piece of the legislation. And then again, OST was created. The interesting thing about the creation of OST, there's a sunset provision, sunset clause in that legislation that after trust reforms are completed, the special trustee could sunset the office, could make the office permanent, or could continue with trust reform. And that would be a report back to Congress. So we're kind of at this juncture with OST in a sense. It came about with the Indian Trust Asset Reform Act in 2016, and I've presented on this before. Some of you may be aware of it. But in response to ITARA, we identified OST's functions. And Congress was interested in what were the non-monetary functions that we were providing, and really at that time it was appraisals. But we concentrated and did our consultation on the management, the collection, which BIA actually collects, but and the investment of these trust funds are primary responsibilities. And because OST had developed this comprehensive fiduciary trust model with beneficiary services, we started seeing these interrelated functions. So more than accounting, we started seeing, in addition to the oversight, we started seeing beneficiary services, a beneficiary focus on participation, part of our mission, provided by our trust officers who were put out in the field starting about 2003, 2004, also a call center to assist our beneficiaries. And one of the reasons why I like to share with you our functions and our services, these are resources for you. I know there's going to be a will drafting clinic tomorrow, I believe, and our trust officers will be attending, the tribe will be attending to assist with getting the information and assisting with providing the beneficiaries with what they own. This next slide demonstrates some of the complexity and the importance of our work. We manage about $5 billion, invest about $5 million. It's a lot of funds. And we've implemented a modernized fiduciary trust accounting system to do that. But when you look at over 80% of the funds, about $4 billion, are managed for 250 tribes, about 3,000 accounts, in individual portfolios based on that tribe's cash flow objectives. About 17% of the funds is managed in a pooled account for our individual Indian. We call them, that's where we get the IIM, Individual Indian Monies accounts. It's a pooled account. It's a savings-like account. You get your funds. You get an income factor. It's been posting around 2.8%, 3%, so it's been a pretty good investment. But where the complexity comes in is when you look at the number of accounts managed, 99% of the accounts we manage are for individual Indians, the IIM accounts. So when you think about the work that we need to do to manage those accounts and the estates that we have to complete, that's where the complexity comes in, and that's where you come in and your importance in this topic and understanding it. All right, it wouldn't be a presentation without some acronyms, some federal acronyms. So trust reform systems. I'm just going to share a few, and then I'm going to show you the impact of some of those. So the trust funds accounting system is OST's system. And again, with trust reform, this thought of having a universal system where everyone could see what is going on, the authorized users. Now, I will share, if we do this again next year, this acronym may change because we have changed vendors here recently, and we're going to be changing to a bank-like type system. We're hoping to have some of those type of functions, some mobile applications. So we're really excited about it to kind of get us into that 21st century. TAMS is BIA's system. The official system of land ownership comes from TAMS. Indian Trust Systems Query is a system that OST's put together that we can see both of these systems together. So authorized users like Carrie and Lynette, they don't have to log into all these systems. They can go in and see what the landowner owns, what the leases are. ProTrack is something that Judge Waite's very familiar with. It's the BIA probate tracking system. Trust Beneficiary Call Center, again, part of our field operations, established in 2004. It's located in Albuquerque. Beneficiaries can call Monday through Friday, Saturday till noon. Most questions, 97% of them, are answered on their first call. It's a great customer service. American Indian Records Repository, the AIR. So when you think about being a trustee, the records are critically important, and storing those records is incredibly important. So that's OST's system. So what does it look like? And I don't know if you guys, did we get books this time? Where's this at? I think we had the books with the PowerPoints available.
Yeah, you had to pay $35 to get one.
Oh.
They weren't ready.
Oh, they weren't ready? I was gonna say, oh, okay. Well, I apologize because this is gonna be a little harder to see. But beneficiaries now receive statements so that when they get a check, they know what that check is for. We've been doing this for about 10 years now, but it is still pretty unique, because back in the day, you just got a check. You didn't know if it was for your farm lease or if it was oil and gas or what it was for. But now on their statements, because TAMS and TFAS share information, we have the funds information. And if you, nobody can see this, right? Can anybody see it? So eye test. I apologize.
It was emailed yesterday.
Oh, it was emailed? Oh, if you check your emails. But in any event, you can see cash receipted in of $100. This information is normally protected by the Privacy Act, and so this is a fictitious, it's John Doe, his account. But it was receipted in, it's for a farm pasture. It actually shows their ownership percentage of 0.30000, and those zeros go way out. And it's not uncommon to see a number that is that far out with the fractionated interest. Also, there's receipted in for oil and gas, a bonus, a royalty, and then the money was dispersed out as a check. And so it provides a lot of information to the landowner that they didn't have before. And it also provides a list of the real property assets of what they own in trust. And this is what's really unique. Because if you could see this statement, it shows this individual owns in multiple states, they own multiple interests. It generally provides your decimal ownership. It provides the allotment, which is generally the original allottee's name, so it can be very historical for some folks. The number of acres, the location, this has like somewhere Oregon, anywhere Oregon. It also shows the ownership classification, title and beneficial. When you see both, that individual has the beneficial use of their property as well as the title. But there's one here where the individual owns title and not the beneficial. That means they're not going to be getting any income off of that property, probably because someone has life estate. And that's something you're going to hear more about as well, that tool that you can utilize. It also shows encumbrances, and Carrie and Lynette deal with this all the time. They will probably explain this a little bit better than I can, but it provides encumbrances that you have on your property, whether it's a lease, if that lease terminates, whether it's a right-of-way, if it's perpetual. So it gives a whole lot of information that the landowner may not have had unless they were at the agency and could get that information. And they would have to go to multiple agencies sometimes to get that information. So a real improvement in our beneficiary participation. So again, some of the beneficiary services that OST provides. Our call center, again, about 2 million calls that they've answered since 2004. Call the toll-free number, and again, they can answer a lot of questions. Now, the reason why they can do that is because they have access to these trust reform systems that we've been talking about. And it's universal, so it doesn't matter where your land is located or where you're located. Our field operations, our fiduciary trust officers, primary points of contact out in the field, providing assistance with trust-related matters, providing financial education, as well as estate planning information. And appraisals. Again, appraisals was something under the Indian Trust Asset Reform Act. Congress recommended, suggested, and said, hey, appraisals should be administered by a single entity. So we did consultation on that, and it appeared that the best consolidation for appraisals would be with the federal land appraisers. So we have, and they're separate programs, but they are two great programs working together and aligned under the director, who is now John Ross. Next week, the 24th and the 25th, there are 2 telephonic consultations for tribes to learn more about this consolidation. That was posted in the Federal Register. If you need that information, let me know. So the American Indian Records Repository, the AIR. It's a state-of-the-art underground, literally 85 feet under the ground facility. It opened about 14 years ago, and it was our effort on the federal government side to get all trust records co-located in one area. And we have millions of records there now. A lot of records housed, some from as early as 1700. It's remarkable. And the way that these out in the field are boxed and indexed, when they're boxed and indexed down at the AIR, they can retrieve these records for individuals within a day. It's actually within the hour now. But it's a system that has been in place now, and they've definitely perfected it. And this is what it looks like. Some of you can see it, but it actually is a cave. You drive into it. It's an old limestone mine. You drive into it, the trucks drive into it with these boxes of records, and looks like a little office, American Indian Records Repository there. And again, I apologize that you can't see it, but there's just rows and rows of these boxes of records, like a football field full of them. And they know where records are located, the way that they have them indexed. It's very unique. Again, just there are offices there, conference rooms. When you actually get there, after a while you forget you're in the cave, except you don't have any cell service. And that's about to change because we're going to be going wireless here shortly. But if you can see this individual here working, they cover the boxes, they do everything they can to protect those records as they're working with them. And the unique thing that we've been working on, because storage, even this type of storage is less, but it gets expensive. So we've been working on a project, we call it the Digital Center of Excellence. We've had a pilot project, and it's more than just imaging, you know, it's a digital encoding. And the pilot project identified a couple things. They took 100 most requested boxes, which happened to be education boxes. I would have thought they would have been litigation, but education. And as they were completing the pilot project, I kind of asked them, you know, what did you learn? And they learned that they could digitize almost anything, books, big maps. They also learned that teachers like to use a lot of staples. And so they meticulously would remove these staples. They didn't replace them all, but they realized they could keep the quality of the documents. So our hope is, and with technology someday, you'll be sitting at your desk, if you're drafting a trust document, it will be digitized and stored immediately and for historical purposes retained. So that's our goal down the road, because storage, again, is expensive. So we're talking about bringing records above ground. So OST is evolving, trust is evolving as it should be. And I'll be completing with evolution of federal law through litigation, the Cobell litigation. If you recall, the 1994 Act said there would be an accounting. So a few years after the legislation was passed, Eloise Cobell, an advocate from Blackfeet from here in Montana, brought a class action suit on behalf of all IIM account holders, requested an accounting and alleged mismanagement of funds. And that litigation lasted for some time, and it was settled. Congress recognized that settlement in the Claims Resolution Act in 2010. And the settlement was $3.4 billion. And so when we are looking at our efforts, I know at OST, and managing the funds, we certainly keep in mind we do not want to go back. We want to make sure that we are maintaining the integrity of the trust. One of the things that was unique and that came about because of Cobell, because we had a settlement, we had an agreed upon balance of the IIM accounts. And so our independent audit that we have every year recognized and gave us an unmodified opinion, meaning the books were in order. And we have maintained that status for 5 consecutive years now. So that's extremely important. We've had a number of tribal trust cases settled, but not enough to where we can get to that point where we have agreed upon balance for that, you know, $4+ billion. But we're working on that. Part of the settlement was a payment to class members, but the other part, $1.9 billion, established a voluntary land buyback program. And one of the things that ILCA recognized in 2000 established a land buyback program, because there started to be this recognition that through probate, you would eventually reduce some of the fractionation. But purchasing it is also another way that you would be able to reduce it. So we started seeing this recognition, if we could purchase it, it might even it out. I think with the land buyback program, they've seen some of that even out. Of course, as soon as we quit purchasing it, it may go back up again. But I provided a website, there's a video about what the land buyback program is. And again, a picture of Eloise Cobell. The program, or the settlement providing the funds are appropriated funds. To administer the program, we utilize this settlement. There's 15% that we use for the administration. So there's a small land buyback staff, and then they procure services from OST and BIA to actually operate the program. So our trust officers, our field operations have been very involved with the program. It's a 10-year program. They actually started purchasing in 2013. So it will be limited, but they're not using anywhere near the 15% administrative funds, so those funds will go into being able to purchase more land. Land buyback has been here in Montana. It sounds like it'll be coming back. And a unique opportunity for individuals to look at what they own and make informed decisions. On this particular PowerPoint, I provided the status report for 2015. 2016 is available. 2017 will be available shortly. That takes us to the estate complexities, and again, why we're here. And we maintain 400,000 accounts. That's a lot of accounts. And many of these have minimal amounts. Now, some of that is because of the way that we set them up. Landowners have an option. They can keep their funds in what we call voluntary hold. And again, it's like a savings account. They can request funds when they want. But we also have it set up to where they'll disperse out. So if you have $15 or more, it'll disperse out to your checking or savings, preferably by electronic or by check. $5 for oil and gas. Well, if you recall, I said, you know, if there's any funds in that account, any land, we must probate that particular trust asset. And what ends up happening is oftentimes the funds will go out, but there may not always be a zero balance. So we have a number of accounts that they do have minimal amounts because they're waiting for the next receipt to come in, and they'll go out. So it's understandable. Again, in all estates, no matter what the value, we're gonna have to probate that. And the cost is basically about the same. We put an average about $3,000, about 2 years. So if you think about an individual that you're working with and you're asking them about their IIM account, and if they should mention to you that they're using funds coming in and their families depending on those funds, you've got to keep that in mind because it may be a couple years before they have access to those funds. And I know there's an effort with regulations to kind of open up what can be used with the funds in an estate account when someone has passed away, because funeral expenses are getting higher and higher. The regulations haven't been changed in a long time, but it's very difficult to get to those funds after the person has passed away. So something to keep in mind when you're working with your clients. And we have about 45,000 estate accounts that we have coded as estates on our IIM system. So OST, with our federal partners, we continue to work on probate reform initiatives. I always like to share that with folks like you because oftentimes innovation comes from the outside, ideas. There are some things we just don't have the authority to use yet, like the private sector. In the private sector, non-probate transfers are utilized all the time, payable on death for checking accounts. Beneficiary deeds are getting more and more popular in Montana, and those are things that you can use that when the person passes, that document takes over and you don't even have to do a probate. We don't have those options yet. We have in APRA the opportunity to have a demonstration project for family-owned trust. But we have this really interesting dynamic because the legislation requires regulations. We've had a thought that if we had the demonstration project, that would help us develop the regulations. So we've kind of had this circular thing going on. So we don't have those yet, but we have those opportunities in the legislation. Gift deeds is an avenue in which, or an instrument that you can utilize if your client would like to gift deed their interest to a child, to someone that's eligible, maintain a life estate for themselves, retain that life estate interest. It's an option. But we've had, and if you think back when I was talking about the Burke Act, and we had allotments, lost their trust status in just a matter of years, we know there might have been some shenanigans going on there. So the federal process tends to be complex for a reason, to make sure that the individual, that their wishes are being adhered to. So oftentimes the gift deed process can be very slow. That's something that we're also working on. You have also the possibility that the individual their children may predecease them, and they don't own that interest anymore. Sometimes that's really hard to tell someone that their child's passed away, but they gift deeded their property. So sometimes the joint tenancy right of survivorship is an option. But there are those options. Small estate affidavits, we use them here in Montana all the time. We don't really have that option. We have a limited option. That's something else that we're looking at revising, possibly through regulation, to be able to utilize that to expedite some of these cases. But the difficulty too, if that particular interest in the IIM account is funds from trust land, you still have the land that will have to be adjudicated. So it's not always simple, right? Unclaimed property fund. We have about 60,000 accounts coded as WAU, our code for whereabouts unknown. Now some of those are because a person received a statement was sent to an old address and it came back, and so their account is just automatically updated to whereabouts unknown, and our trust officers, county techs reach out and they can update the address. But we have some folks we just have not been able to find for a long time. So there's been a thought that we would create a single fund for these WAUs, and we do a couple things. The beneficiary or an heir could always come back and have claim to those funds, but we wouldn't have to put those particular accounts in probate. So that would be one avenue of reducing some of the estate accounts that we have. Now, tribes initially opposed this, again, some of the mistrust, but I think because our accounting systems have developed and evolved to a point where we can actually account for those, having a combined fund doesn't seem to be as much of a concern anymore. So that's another possibility. So our main topic of today, APRA. Again, we've talked about these bullet points, and you're going to hear more about them. But certainly, I'm hoping that this overview has demonstrated some of the need for the beneficiary Indian estate planning for our landowners. The main objectives of APRA and what you're going to hear from our folks is to explain what's going to happen to the trust property without a will, what's going to happen with the will. We also have some tools that can influence the disposition of property of the decedent. Renunciation, consolidation agreements, and purchase at probate. These are new tools. There's still challenges with some of these tools. Judge Waits will discuss some of those. But just be aware of those and things that you need to know. I mean, what is a valid will? How do you use a will to reduce the fractionated interest? What if you have an adopted child? What if you have a divorce? Some of these things have changed. And again, APRA was signed into law in 2004 and it became effective June 20th, 2006. Now, you're sitting there thinking, hey, anybody I'm talking to today, APRA's going to apply, right? That's true, yes. It's still an important date to remember. There's a couple things that I've experienced. One, you may be working with someone that has someone in their family that an estate has been reopened for whatever reason, found more property, found something that's been reopened, being modified. And that may have been pre-APRA, so it's going to be a little different. The other thing is you may be working with someone and they've been through a probate before with a family member, and certain things happened. And it was prior to APRA, and those certain things may not happen again. And so sometimes you have to just be able to explain, federal laws kicked in, why that was different. So it's just an important date to remember, and you're going to hear it a couple times. I know some of you can see this picture. I like to share it. It's where we're standing now. It's a Salish encampment. It was a common gathering ground for the Salish people, for other tribes. Used to dig bitterroot here, and obviously we've changed, right? We're going through an evolution, we've changed. So I like to share this couple thoughts. Dr. Gita Swaney, she's a member of CSKT. She's a professor here at U of M psychology department. She's getting ready to retire, but she provides this presentation on the clash of cultures, and it's very interesting. And if you think about what we've been talking about, it's the Western perspective, and I apologize, some of you guys on the side can't see it, but it's the Western perspective of the initial discovery and contact, of population decline, of acculturation and assimilation, and this reinvention of an ethnic culture. But some of your clients and the folks that you're going to be working with are going to have an indigenous perspective, a perspective of contact and evasion, of genocide and destruction, of resilience, the resistance and survival, and this recovery as indigenous people. When we were talking about the land buyback program and these very small interests, sometimes they're referred to, and you'll see law review articles written about a spoonful of dirt. And that's true, I guess you could think about it that way. Of course, it's that spoonful of dirt of the whole allotment, but it means something generally to folks. You know, it can represent their culture, their heritage, it may have meaning. But what's been interesting about the land buyback program, when it was initially being implemented, there was a thought folks wouldn't want to sell their interest. But they found that folks have been interested in selling. And I think it's because of the efforts of like CSKT and their vision and mission to regain the land ownership for the self-sufficiency of their membership. It's still part of your culture, it's still part of your meaning. Even though the tribe may own it now, it's a bigger meaning. And those of you practicing in Montana, it's always important to remind ourselves that we have 7 federally recognized reservations, 1 state recognized Aboriginal territory throughout. But for OST, we have 40,000 IIM accounts, of these home agencies combined. Now that doesn't count the individuals who may live here who are from another reservation. So we have a number of folks that you may have the opportunity to meet and estate plan for.
What is the Greenland? I can't.
Let me go back. The Greenland, so the orange represents the reservations, and then you see different Aboriginal territories based on the tribes. So it's pretty much throughout. Apologize, you can't see it better. And that pretty much concludes what I have. I went right on an hour. I'm sorry, I wanted to leave a little bit more time for questions, but I've provided some websites. I hope you get the materials. If they've emailed them, great. If they haven't, let me know. I'll email it to you. Yes.
We have questions?
Yes.
Okay,
Maybe, Andrea. No,
Oh, well,
no, I'm
Good job.
kidding. I'm kidding. One of our advocates from CSKT back in the day, we worked together, so,
Good work, yeah.
yes.
And it is good to see you back here. Welcome.
Yes, I'm happy to be home.
So my 2 questions are, first, did APRA change the status of tribal laws? For instance, does APRA, okay, did it change the status for adopted children, the ones that have been adopted by others?
Good question. And Judge Ways may have a more comprehensive answer. But in general, yes, APRA addresses adopted children. APRA still recognizes tribal probate codes, and there's still federal codes for some tribes. But it did change, but generally the federal government in adjudicating a case is going to be honoring that tribal probate code.
And then the second question would be, because we talked about IAM accounts and tribal real property, what about houses that sit on tribal trust land? And how, can you talk about how that complicates things a bit?
And again, Judge Wace will have some, it complicates it, and I don't think we've clearly addressed it as well as we would like, because it's still personality, and so it is complicated. It's one of the things that we work with a lot where someone has built on trust property. The other piece that you'll come into every once in a while is someone will have a home on a tribal lease property, and they've had it for so long, and they feel like they own it, but it still belongs to the tribe, and you would have to follow tribal rules and laws to pass on that home, meaning whoever you're passing on to would have to be eligible for that lease, so that can be complicated as well, but you run into those two. But you'll see some examples here. I think Judge Waits, as he goes through the presentation, you'll see more examples of that. But very good questions, Andrea. And did you want to add anything on the adoption piece? I know you cover it later.
I'll cover it.
More extensively? Yeah, great. Well, thank you. Thank you very much for your attention. Thank you for being here. I really super appreciate it. I apologize to the folks that we've been webcasting. If you've been having difficulty hearing us, that's something, please put it in your evaluation and we will work very hard to try to work on that. Because I've participated in those before and I know how difficult and challenging that can be. And hello. We got to start over. Dave's here. No.